I hope my time is frozen, Your Lordship.
Yes, it is. Thank you.
Your Lordship, first of all, when this petition was filed, just from the facts of the case, a certificate of electronic evidence was sworn by one Maingi Brian Murithi.
Yes.
That certificate, it's actually an affidavit, Your Lordship. It was dated the 21st day of August 2024. Your Lordship, subsequently you gave leave for the petitioner to file an amended petition together with any other documents that they wish to rely upon for purposes of that petition, Your Lordship. Now, Your Lordship, subsequently we were served with the amended petition together with all the documents that they seek to rely on. Then, Your Lordship, when I was going through the documents, I found out, or rather I discovered, that there is some discrepancies in terms of the certificate of production of electronic evidence, Your Lordship. These I raised in my submissions, Your Lordship. My submissions are dated the 11th of February 2025, Your Lordship.
What is the discrepancy?
Now, Your Lordship, the first discrepancy was particularly for the videos marked, and I will list them, Your Lordship. For the videos marked BKM6, BKM7, KM7 and BKM9, KM10,
sorry, KM, the first KM,
KM7 and BKM9, KM10 and VKM1, Your Lordship. I raised the issue, Your Lordship, in my submissions,
yes,
that the certificate produced therewith is defective and not compliant with Section 106 of the Evidence Act. The section, Your Lordship, gives clear details, or clear provisions of what a certificate should contain, including the evidence that they seek to rely upon, Your Lordship. Now, Your Lordship, subsequently, after my submissions, on Tuesday, Your Lordship,
yes,
I am served with another certificate by the same Brian Maingi Murithi. And Your Lordship, this certificate is in essence attempting to cure the issues I have raised in the submissions, Your Lordship. Your Lordship can confirm from CTS when that certificate was filed, sorry. That was on Tuesday, Your Lordship. So, Your Lordship, at the very least, even just from the factual basis, without even going into everything, there needs to be a reciprocity between colleagues in the profession. We cannot operate like this, Your Lordship. I can't file submissions raising issues and you simply serve me with a certificate and you say that is enough. So then the videos that are sought to be produced, in fact, Your Lordship, the ones that have been added are in red. And I'm referring to the certificate by Brian Murithi. The same is dated 27th January, Your Lordship. And yes, equally, Your Lordship, that certificate was served on Tuesday, but is backdated to 27th January, Your Lordship. And it was served on Tuesday. So then what is the fate of my submissions on this issue? Because a certificate is just produced and you're told, yeah, that is enough. Equally, Your Lordship, in these videos...
Yes.
What is your response?
I let my senior address you on that issue.
Sorry, my lucky.
Just a moment. Let's take it limb by limb.
Okay.
Yes, Councilman.
Yes, my Lord, what Section 106 of the Evidence Act requires is that video evidence be accompanied by a certificate.
Yes.
So be supported by a certificate.
Yes.
My Lord, I don't know it to be the law. As a matter of principle, even going with the fact that the law, I don't know it to be the law that the certificate must be filed at the time of filing the video evidence. I don't know that to be the law. Indeed, my Lord, even if no certificate had been filed,
Yes.
there is no prohibition in law for the petitioner to supply that certificate now in court. There's no prohibition in law.
Yes.
As I understand it, the purpose of the certificate is to authenticate the video. The purpose of the certificate is to authenticate the video. So that without going into the other minor facts of when because I need to cross-check with our filing team now to get those minor details. As a matter of fact, on principle, Council does not dispute that as we seek to play these videos today, there is a certificate authenticating that. So in view of that, in principle, I don't understand what substantive law has been violated in view of the concession that as we seek to play these videos now, there is a certificate backing each of the videos that we seek to play. There are other issues. Council referred to BKM as some of the videos. We have no videos under that label. We only have videos under KM7, KM10, and BKM1. So when you refer to, I had referred to BKM, those were just documentary annexures. So we're also trying to cross-check our documents just to confirm that there was no error in the branding, and I confirmed that there are no certificates under BKM. The first three.
What is the source of these three videos?
They are set out in the certificate as the various websites are set out in the certificate. The Senate's own website. The Senate's own website. The Senate's own website.
Your Lordship, I beg to differ. Particularly KM10 is from a YouTube video from a channel known as Kenya News Alert TV. How is that a Senate video?
Left my laptop. Someone have a copy of the two certificates. Did not be printed to my laptop.
If you look at volume number 9, at page 85 to page 89, is the certificate dated 27th January 2025. That's number 1.
Your Lordship, I can spare your time. I have both certificates here.
That's thank you. While at it, again, the court will take judicial notice of the fact that our parliament has a parliamentary broadcasting unit. To my knowledge, and since Council is with Parliament, he can verify these facts if the contrary, is that broadcasts from Parliament come through the parliamentary broadcasting unit. That's the primary source of all broadcasts of Parliament.
Yes.
And number 3, and more importantly, if there was any material discrepancy in the content of the video, material, substantive discrepancy, since the parliamentary broadcasting unit under the control of the respondent is the primary broadcaster and primary repository of all these broadcasts, nothing was easier than then to bring us another video showing that here is the authentic video from the unit, and here is how.
Just a moment, Councilman.
Yes.
Just a moment. Is there a challenge to the authenticity of the video?
Your Lordship, particularly the video on VKM10, which is and maybe that's not the one they were going to play, but Your Lordship, I don't know if I should keep objecting to the videos as they go, or I just raise them all.
Well, let's sort this out at this junction. I don't have a BKM referred to in the affidavit that you handed. Sorry, the certificate you handed.
Oh, sorry.
The one dated 27th January 2020.
Your Lordship, sorry, it's KM10. KM10.
BKM1, KM10, yes.
Yes.
What is wrong with KM10?
Your Lordship, this video is from an unknown account called Kenya News Alerts TV, Your Lordship. Even if I don't give another video to controvert that, Your Lordship, who is Kenya News Alerts TV? Can we call them here and cross-examine them about where they got this content, Your Lordship? It just is the law, or should we ask counsel?
So your objection is for KM10. You have a problem with BM1 and KM7?
Yes, Your Lordship.
So I've had you on KM10, BKM1.
Your Lordship, this one was not even accessible. Let's even begin at the basic. It was not accessible, Your Lordship. VKM1. So we are here, we are playing videos, Your Lordship, like VK1, M1. I have not seen the video. I don't even know which best the approach to go about it, Your Lordship.
Let's watch the videos first.
My Lord,
Yes.
sorry. I just needed to contribute briefly on this and just help us move forward.
Yes.
By saying that counsel is very lucky because he's practicing when we have the 2010 Constitution.
Yes.
And what he's raising is what Article 159(2)(c) came to protect us against. Unnecessary and procedural objections on technicalities when the authenticity of the documents and the videos are not in question. If counsel was served by the petitioners in December or early January, what stopped him from sending any requests or saying, counsel, my video is not starting. So basically, let's proceed so that he's given an opportunity to submit on those videos when they are being seen. Otherwise, let's not bring in technicalities that don't go to the substance of this matter. Thank you.
Let's watch the videos. Let's begin.
I think you've got us out. We had an objection to the issue of the videos.
Yes.
A different limb altogether from what Mr. Mukele has raised.
Yes.
And if you allow me, Your Lordship,
Yes.
we took directions on the 18th of December on how we shall proceed today.
Yes.
Those directions were very categorical. We shall proceed by way of highlighting submissions.
Yes.
My Lord, I'm at pains to find a section in the Evidence Act that says that during highlighting of submissions, you can play videos. To my understanding, Your Lordship, that amounts to adducing evidence. It amounts to calling a witness to speak to the video so that then we can test the veracity and authenticity of that particular evidence that is being portrayed in the video. My Lord, that was not the intention that we had when we gave directions on the 18th of December as to how we shall proceed today. My Lord, as if that is not
Just a
enough.
moment. Just a moment. Councillor Ngoe, on that point.
Just very briefly, we are proceeding on affidavit evidence. The affidavits have annexures. Where the annexures are written texts, like the Hansards and the letters, we read out as we have been doing. Where the annexures are videos, how else do you access videos? You see them. The contrary is more unjust. The contrary is where we don't play these videos, but because it's evidence, the court goes and plays them without the benefit of the party's comment or observation. That would be more unjust even to the respondent. I mean, how would they see it completely? So, the playing of these videos is just a reference to the contents of the affidavit. The affidavit says, on this day there was pandemonium, evidence of that pandemonium is in this video. So we are not going outside affidavit evidence. We're actually just referring to the material in the affidavit evidence. My Lord, please plead with our learned colleagues to allow us to proceed with this hearing. We know why they fear these videos, we have no doubt about it, but it's in the nature of a trial. Some parts of a case are just unfavorable to you, and you live with it. You can't run away from it. Please allow us to proceed with the hearing.
My Lord, if I may clarify initially before the court about just a little on the issue of section 106B of the Evidence Act and admissibility of the video there. My Lord, I refer you to the case of Republic versus Barisa Wayu Matugunda. My Lord, it's a 2011 case which interprets section 106B and how parties should comply with the same. My Lord, the court said very clearly that this provision makes it abundantly clear that for electronic evidence to be deemed admissible, it must be accompanied by a certificate in terms of section 106B. The question before the court, my Lord, is whether that evidence was accompanied by that certificate of electronic record. The petitioner has admitted that it was not accompanied by the same. They only filed it after it was raised by the Speaker of the Senate. It follows therefore, my Lord, it cannot be admitted before the court. It is tried by ambush, and the same thing should be struck out from the court.
Sorry, my Lord, and it's not my nature to do this. The council have misled you in the authority he just cited a short while ago, because he read a part of it and the authority says the contrary.
Yes.
Paragraph 30 of that authority, the court says, I am alive to the fact that the applicants are not fighting the contents of the document, but the lack of the certificate. I agree with the learned trial magistrate that it's in the interest of justice that the respondents be allowed to produce the certificate at that time in the trial, and for the court to deal with the evidence on its merits. The objection by the applicant is therefore overruled and the application dismissed. This impeachment shows that an objection like theirs was overruled and the party seeking to produce the certificate allowed to produce it. How can council cite an authority partially, particularly where it's not supplied in advance? Council has a strong ethical duty when citing an authority ex tempore to be extremely candid. Otherwise, the authority my learned colleague has referred to at paragraphs 30 to 31 of the ruling of your sister, sorry, my apologies, Justice Mumbuati Mateka, which is the one she's referring to, I thought, says the exact opposite conclusion of the one he's inviting this court to find. That's revision number E006 of 2021. To the extent that's not the one, then there is authority to that effect. George Gabriel Gekuru and another versus Republic, where the court allowed a certificate on the day of the hearing and allowed the evidence to be referred to because there is no substantive contest on the content of the evidence.
My Lord, I'm not sure whether council got the data referred to. So the authority is the Republic versus Barisa Wayu Matugunda. It's a 2011 case, my Lord. And the court concludes as follows. In fact, the court concludes that this provision makes it abundantly clear And for electronic evidence to be deemed admissible, it must be accompanied by certificate in terms of section 106B. Without the required certificate, this CD, which was a CD in that case, is inadmissible. As inadmissible as evidence, and I don't know the same. And television is by Justice Odero.
And my Lord, to respond to what my senior Kasongoya raised about them being allowed to produce that certificate. Now,
Yes.
the meaning of the word accompany is ordinarily that those two must be brought at the same time, concurrently. And my Lord, the issue here is not even mostly about that certificate. It is also about the accuracy and veracity of those videos, because we do not have the source of the videos. We do not have anybody we can cross-examine on the occurrences of those videos. For all we know, they could be AI generated. They could be deepfakes. The internet has advanced recently, my Lord, and it's possible to do those things. There is no affidavit that is accompanying those videos. Therefore, there's no person we can put on the stand and cross-examine on the veracity and accuracy of those videos.
Let me give my short ruling on that. Counsel for the petitioner has conceded that the playing of the videos today would allow comment and observation by the parties. I agree with Counsel Kirimi in that regard, that it would blur the distinction between hearing and highlighting of written submissions. Counsel Mukele and Counsel Mwaria have, on the limb of objection on electronic certificates, have stated this is canvassed in their respective written submissions. Consequently, 1, the videos shall not be played today at highlighting, and the court shall view the videos through the stated links that are given in the petitioner's affidavits and certificates of production of electronic evidence. 2, the question of certificates shall be canvassed in the judgment as the certificates have been produced and we are past the hearing stage, and there is no question being raised to authenticity substantively. The objections are in the opposing parties' written submissions. If the objections in the submissions exceed, the court shall determine as much and not rely on videos. Parties are reminded that in addition to producing evidence, there is material in the public realm on this issue. So that's 21st February 2025. I've read the affidavit and I've read the written submissions. I understand, and I'm sure the opposing parties understand the direction that the videos being played today would have gone. The challenge is if you're opposing something that is already in the public realm, it's canvassed on news reports, the judge may say, that's fine, I strike out the videos, but the judge cannot erase what the judge read in newspapers or saw on television. So that issue is dealt with, unless someone wants to raise another objection.
My Lord, not another objection, but in your ruling that you've just given, you have said that no objection has been raised to the authenticity.
You cannot say authenticity is we do not know. You cannot prove, you cannot assert a negative. You have to say this is AI generated because we ran it through software and it said this is AI generated content. We have very many publicly available software. It cannot be enough for you to say I don't know if it is authentic, therefore it should not be submitted.
We are guided, my Lord, but we hope our objection has been registered on the side.
Counsel. Counsel, please rise. Please rise. Counsel, which video is inauthentic? So that I record which video is.
Your Lordship, we contend that all of them are inauthentic.
Why?
Because we cannot test the veracity of those videos.
If you cannot test the veracity of the videos on the 21st of February for documents that were filed well back, what is the court supposed to do, Counsel? You should have taken these links. You should have tested them. Run them through freely available software. You cannot say you want to reserve something that you cannot prove.
Your Lordship, it's a law that a party that makes a certain assertion should prove it. It's the duty of the petitioner.
Assertion that this could be AI generated.
And it is also the duty of the petitioner to provide reliable and authentic evidence.
You cannot say that something is inauthentic because you have not confirmed whether or not it is authentic. The certificate is supposed to give you the opportunity to then dispel the contentions that are being made. I will not record a reservation because I cannot see a reservation.
Your Lordship, I think we're in agreement, me and you. It's just we're in agreement because our issue is that this certificate was filed on 19th of February, way after we had filed our submissions.
Let me give my view on that. My view has always been, even in private practice as a practitioner, you should object to something when it is being produced as an exhibit. Not even marked for identification, when it is then being produced as an exhibit. Because the party may elect never to produce it, so it will not be an exhibit. In civil trials, particularly in the way we have canvassed this petition, the moment we went beyond here, then whatever is on record is on record. Sadly, highlighting original submissions is not the time for challenge. So the videos will not be played. I will access the links. If there's a link that is not working, as has been stated by one of the council opposing, then, and please don't change the links because you can't, it can't change the links. And I'm savvy enough to see if I look at the upload date, and the upload date is different. If the upload date is after the filing of this certificate, then we have a very, very big problem. So please don't tamper with this. We were at the last name again?
Yes, most obliged, Your Lordship. Perhaps I also want to point out that the respondent is the custodian of the websites.
I will consider that in the...
Yes.
Let's not have any more that. I'll consider it in the...
Thank you, Lordship. In the absence of the videos, Your Lordship, allow me submit, like I started by saying,